Estate planning, Michelle Audette. Thank you for being here, Michelle.
Am I hooked up? Am I on? Wow, I feel like really important. Like I'm a TV evangelist in a mega church or something. But I could really just sit here and listen to nice things that you're saying. That really, really makes it all worthwhile. We work very hard. We have 2 offices. We have 2 beautiful grandbabies. They live in D.C., so if I'm not working, I'm on an airplane going to D.C. So when I'm here, I work most weekends, and not Saturdays I watch college football all day. But so we have a lot to cover. How many of you in here have wills already? Oh, good. Y'all are already a step ahead of a lot of people. I kind of got into this. I started as a prosecutor in the DA's office, and then I was a criminal defense attorney, and then eventually, after about 13 years, I kind of had my fill, so it took me a long time to get out of all that. But we transitioned into helping people do estate planning and Medicaid planning, very rewarding. I had one grandmother that lived to be 96, one that lived to be 98. My mother's 93. She still drives herself to church and lives by herself, so we have a long history. But both of my grandmothers were eventually on Medicaid, and I kind of learned it the rough way at home with 2 babies, and she was in Tennessee. But there's a lot of rules, and it's a wonderful program, helps a lot of people. But I'm going to talk more about estate planning and the documents that you have to have. These aren't like something that you maybe should think about. These are things that you have to have. You have is that clicker? I got stuff in my pocket and clickers. Okay, so let's get started. Jim's made you copies of everything. The theme that I've always used is you can't take it with you, but you can have the last word, meaning I get people in my office all the time. I want my Tupperware. I want my china. I want this to go to my son, and he better not ever sell it. And he cannot give it to his wife because I don't like her. I'll give $30,000 to my grandson as long as he's drug-free for a year. Well, guess what? You can't rule from the grave. So when you're giving things to people in your will, it's at the moment that you die and they get it. And you have nothing to say about what they do with it. You can give someone a life estate, so they don't actually own the property. They can just live in it during their lifetime. If they die, it goes to the next person. Or if they abandon the property, it goes to the next person. But you have to plan for all this, and you need to be a participant in your last years. You need to be a participant in your death, so to speak. And you can do that by having a will and letting everybody know what you want. So we're going to talk about wills. We're going to talk about power of attorneys. There's two types of power of attorneys that we'll get into. 10 reasons to create an estate plan now, and don't waddle into my office when you're 95 years old and you're having heart surgery the next day and you want me to get you a will. Because 20 years ago, I would have done it. Now I don't. Although during COVID, we did a lot of crazy stuff because we had to. And we lost a lot of people. We did a lot of probates. We did a lot of notarizing through windows at nursing homes and all kind of crazy stuff. But we made it work. So if you don't plan for your will now and all your documents, what happens if you become incompetent? I had a lady in my office this week. Her husband he's been deemed incompetent by a doctor, and she needs to sell the house. Well, he owns 50% of that house. We are a community property state. Most of you who are married, your property is owned 50% by you, 50% by your spouse. Your spouse dies, his estate or her estate owns that house. It doesn't magically jump over to the other person. People come in my office. We've been married 50 years. We've been married 40 years this year, if you can believe that. But anyhow, they say we've been married so long, he died, so I shouldn't have to go through probate. I'm his only wife. I've been married to him forever. Well, that doesn't happen. You have to go through probate or some mechanism to get it in the other person's name. Because everybody that owns anything, you have the right to choose who gets your stuff. So if you want to be involved in your estate planning, then you need to do it while you still have the capacity to do it. If you have minor children, it's very important because on the will you can actually choose a guardian. You can choose a guardian of the person of the child and a guardian of the estate of the child. So you can have one person to manage the estate or one person to manage the raising of the child. If you die without a will, Texas doesn't jump in and grab your stuff. Everybody comes into my office, I don't want the state to get it. Well, they don't, unless you absolutely have nobody in your lineage. So the state of Texas has laws of intestacy. Intestacy means you've died without a will. So if you're married and you share the same children with your spouse, then everything goes to your spouse. If there's one child outside the marriage, then that child gets their parents' share. So it gets a little tricky. So if you want to decide who gets all your stuff, you need a will. Or we go through the laws of intestacy. If you run out of kids, you run out of grandkids, and it goes back to sisters, brothers, nieces, nephews, cousins. Everybody has a cousin somewhere. So if all this, the money that you have, the land that you have, all this stuff that you've worked for all of your life, if you want that cousin in Nebraska that you've never even seen to get everything, then maybe just leave it alone. If you have blended families, again, super, super important that you have a will because your stepchildren don't inherit from you, but your wife's children may inherit your stuff. So, if you have a child with special needs, big, big, big deal. Because if a person who is receiving money on a means-based program, meaning they're getting money from the government, and they can't have X amount of money in their bank account, they can't receive a big inheritance. So grandma leaves little Susie $10,000. Little Susie's on Medicaid because she has disabilities. It will kick her off of Medicaid unless you make provisions for a supplemental needs trust. A supplemental needs trust we do, and it's the only kind of trust that you can have and still be on a means-based program. It separates the person from the money, so somebody else manages the trust. Everything's spent for the benefit of that person, but that person has no contact with that trust. No debit card, no checking account, no nothing. And again, when we're doing wills, if there's anyone in your realm or your lineage that might have a disability or is already showing signs of, maybe some mental defect, some bad decision making, drugs, alcohol, whatever, then we want to put in your will, if little Joey gets anything, it should go into a supplemental needs trust. He's still going to get from you what you want him to, but somebody else is going to manage it. Keeping assets in the family. A lot of people have family businesses and they want to keep family businesses. So within your will, you would determine exactly where everything went. If it's going to your son passes away, then it could go to his children, maybe not his wife. And I don't have a thing about wives or husbands. I have the most wonderful son-in-law and a fantastic daughter-in-law, so I don't have a problem with that. Financial security. Make sure, in Texas, we've got probate assets and non-probate assets. Anything that has a beneficiary is a non-probate asset. But you would be so surprised if you go to the bank, maybe your accounts aren't set up the way that you want them to be. In Texas, you can be an owner on accounts, you can be a signer on account. You go into the bank and say, pull my signature card. I want to know who gets what when I die. Because they come up with all these acronyms, and if you work at a bank, I'm not dissing on you, but the TODs, the JTROSs, and you get real confused. So just walk in and say, I want to know who gets this when I die. Because you usually want someone to have access to money, maybe your executor. Because if you're making your kids the executor, they may not have an extra $3,000 or $4,000 to pay for expenses or $50,000 to pay for your funeral. So those are some things to think about. Retirement accounts. Again, make sure you have beneficiaries. If you don't have a beneficiary on an account, say you had your husband set up as a beneficiary, he died before you, you never changed it, you have no beneficiary. Then it flows through your will. So that's why in every will we have the rest and the residue, which is this big gigantic bucket that everything falls into. And then it's divided however you want it. Avoiding probate. Probate in Parker County, specifically Parker County, is still very fun and doable. We have Judge Dean. We do probate every Wednesday. Now, the waiting period, takes, right now, we've caught up since COVID. So you're about 45 days to 60 days out from beginning to end. Once you get in front of the judge, it's like 1 minute to get all the paperwork signed, and then you walk out with letters testamentary, which is the magic ticket that allows you as the executor to go and transfer assets, sell property, and then make divisions of everything. So in Parker County, we still have a pretty simple probate. Tarrant County's, it's okay. Dallas is horrible. So I don't want to do probate in Dallas. So now I am mixed up on my. What are the legal means to prepare for incapacity? Again, there's the statutory durable power of attorney, the medical power of attorney, and the directives of physicians. So within my documents, I do the statutory durable power of attorney, which is the business power of attorney, and then the medical power of attorney is 3 documents in one. It's the HIPAA release, it's the directives to physicians, and the actual medical power of attorney itself. The statutory durable power of attorney is the most important document you'll have while you're alive. However, there may never be a reason to use it, but there may be that one time that if you don't have a business power of attorney where you've made someone the agent to make decisions for you, the only other option you have is guardianship, which is awful, awful, awful. And no, I don't do guardianships. I can give you names of people that do, but I'm not doing one. Because someone is appointed a guardian, they come in and they take over your life. They take over your person and your estate because you haven't nominated anybody else to do that. And if you're incapacitated, that's the only choice you have. And then there's one attorney who's taking care of everything, and there's another attorney who looks over the attorney and the ward to make sure that everything's done correctly. So on a business power of attorney, statutory means it's governed by law. It's in our code book. And now we live in a really tricky world now. Everyone's on eggshells. It's a CYA world. And so these documents they have to be sound. They have to be what the statute says, because if they're not in substantial compliance with our statute, then banks, title companies don't have to take them. And they don't want to take them because they're actually taking a chance when somebody walks in. Because with this document, you can sell property, you can close bank accounts, you can change beneficiaries. And, as we age, and especially if we're getting ready to apply for Medicaid or we're selling a house, if we don't have the capacity and we haven't named somebody that can step into our shoes and take over our business, we're in trouble. And that's where the guardianship comes in.
We're going to go back 2 slides to planning for incapacity. You skipped over 2 slides. So planning for incapacity.
I was already talking about it.
Well, they don't know that. So
That's why I wanted the clicker. Okay.
you see it?
Yes.
Okay.
Yeah, 40 years. Planning for capacity. The capacity of the person determines whether or not they can make binding amendments to their rights, duties, and obligations, such as getting married or entering contracts. Now, we have testamentary capacity, which is a legal definition in that you understand the objects of your bounty. So when someone comes into my office to do documents, even though they have a diagnosis of dementia or some type of confusion, as long as they can sit in front of me without their family helping them, and they can tell me what they're there for, what they want, who their children are, and what they want to live to who, and sometimes why. So the capacity comes in when they're signing the document. So there has been times that I've done a will, they've come in to sign, and they're not in a good place. But that doesn't mean it might not be tomorrow. So just because you have a diagnosis of some type of a mental capacity problem or forgetting or a touch of dementia, we can still do legal documents. Again,
Is there a test, a uniform test that attorneys have, though, for someone like that can be administered? And if they pass the test, then it would hold up later in court.
well, I talk a lot, and my first meetings are usually about an hour to an hour and a half. And so based upon my interactions with them, then I make a decision. There is no standardized test.
My father was given one by an attorney. I was trying to get medical power of attorney from my evil sister to me, and he wanted that, but he was dying of cancer and 88 years old. And so the attorney, but still sharp, the attorney insisted in order to transfer that over legally that he had to be given a written test. And it was 3 or 4 pages long.
Okay, I don't know who the attorney was, and there's nothing in our code book.
Really?
No, there's nothing in the estates code that says there is a test, like, is this dot green or blue or something like that. So I don't know what the test would be, but no. However, when an attorney does a document, my name is on the line.
Right.
I mean, I worked hard for my bar card. I've had it 30 years, and I still need it. So I am not, and I won't ever do a document where I do not think someone completely understands what they're doing. So if someone is evaluated by a doctor, I just saw one last week in my office, and basically when a doctor writes, a letter that says someone is having troubles, that they're senile, it's that they can't manage their food, they can't manage their dressing, they can't make decisions, sign contracts. Now, if somebody comes in and they have a letter like that, then I'm not going to do something, probably. It just depends. But I will talk to them. In Texas, the only 2 ways you can contest a will is if you were not competent and you didn't understand what you were doing when you signed the will, and someone was coercing you, or someone was coercing you or making you do that. I have asked people to leave my office and go sit in the car or on the front porch because they were trying to, not coerce, but remind the person what they wanted to do, or what they had talked about on their way to the my office. So, and it doesn't happen a lot. But I meet with my clients, and again, it's an hour to an hour and a half. We talk about everything, and then they come back a second time to sign the documents. I go over every single page. I can say it in my sleep, but I go over every single page. So I spend a lot of time with these people. And I think I'm a pretty good read of people after all these years. So that's capacity for signing documents. So on the statutory durable power of attorney, again, this is the document that if you're an agent for someone, then you're the person who can take this document and go to the bank and write a check, take out money, sell property if that person needs you to sell property for them. I make them immediately unless there's some extenuating circumstances. Because the only other option we have is to make them springing. And making springing means they only become effective when and if you become incapacitated. And in our world that we live in right now, you would probably have to have a name tag on that said, I am incompetent today. Because that's just how everything is going at this point. And making it effective immediately, it's not a risk. I mean, you don't ever give the person the document unless you're ready for them to use it. I've used my mom's once when she broke her hip and leg and something, and I had to go and do something at the bank. But anyhow, the other document is the medical power of attorney, which is the 3 documents in one. First of all, it's the directives to physicians, where you make a choice. If a doctor certifies in writing that you have a terminal condition or an irreversible condition, both of these conditions are basically the same. We just like to throw in a bunch of words to make it look complicated. But both of these are conditions in such that your doctor is willing to certify in writing that they don't expect that you live 6 months, 3 months, regardless of what they do to you. And your choices are either A, do you want to be kept alive and do you want to just them leave you alone and let you die as gently as possible, or do you want to be hooked up to life support using available life-sustaining treatments? You make your decision on that document, and again, the document actually comes with several pages of definitions that talk about what life-sustaining treatment is, what type of irreversible conditions that people have. Again, it's not that you just, stump your toe and you're at the doctor's office and they, are going to put you under. It's that you have a terminal condition. You already have cancer. You already have kidney failure. You already have something. And then some intervening something happens. And there's your family sitting there. And the doctor's saying, are we going to hook him up to life support? Are we going to trach him? Are we going to give him a feeding tube? And you would have already made a decision on your document. The other most important part about this document is that you share with your agent what your wishes are. Because the last thing you want is your kids or your spouse to be sitting in the room and the doctor says, yeah, we don't think she's going to live anyway. What do you want to do? And they all look at each other. The biggest thing on the medical power of attorney now is the HIPAA. HIPAA used to be about a paragraph long. It's 2 pages now because it's a legal document and it allows doctors to hand you medical records. It allows doctors to talk to you about the person that you are the agent for. It allows you to share records with other doctors, even psychological records, even psychiatric records. It also allows you to gather all the records if you're going to sue somebody, which it's kind of a new thing. So HIPAA's big. And within the document, of course, you're going to name who it is as your medical power of attorney. You can have alternate medical power of attorneys, or you can have them act together. And I can actually put in the document now that Susie and Mary are going to be co-agents for me on my medical power of attorney, but they both don't have to be together at the same time. I trust they're on the same page because I've already told them what I want. So that's a nice thing to have because, I'm an only child and I always think, you have so much responsibility. So if you got a bunch of kids and maybe one's a nurse, choose her. Always choose someone who's a consensus builder. Don't choose, Cindy who goes in the corner and cries, or you just got to be careful who you choose. But I like the idea of having more than one person so that one person is not just sitting there saying, oh no, if I unplug mama, it's going to be all my fault. So I think it's good if you have, someone else to kind of bat the ball back and forth.
What's the difference between a medical power of attorney and a living will?
A living will is more the directives to physicians or the DNRs, do not resuscitate. That's kind of where that came from. So there is another form that's not included in the medical power of attorney, and it's called a DNR, or do not resuscitate. That document you can download from the Texas Health and Human Services. It has to be signed by a doctor, and it has to be signed by the client. Now, what it says is that I already have a condition, and I do not want to be resuscitated, but it only is good outside of hospital settings. So your medical power of attorney controls inside of a facility, nursing home, hospital, whatever. The DNR is when they're transporting you in an ambulance, or you're at a physical therapy place, or something like that. And you can have a copy, and a copy serves the same as the original. You don't have to pay for it. You just download it, but your doctor has to sign it. And you have to have a pre-existing condition.
But a medical power of attorney, if a person does not have the directive or a DNR, the medical power of attorney would be sufficient to make those choices, wouldn't it?
Yes. The medical power of attorney only comes into place when you can't make a medical decision for yourself.
Right.
As long as you can sit up and say yay and nay, then they're going to listen to you.
Right.
Uh-huh.
Do you have co-agents on the statutory durable power of attorney also?
Yes, you can. And that's a great question because I've changed my mind about that lately.
Like brother and sister, the elder mother.
Right. So I like to have, because a lot of our people, we got Susie that lives in Weatherford, and then we got Bobby that lives in Nevada. And I like Bobby better because Bobby knows how to do my bank account. Susie doesn't. But she's here. But, now that we're, internet, everybody, and you can, banks here in Delaware and everywhere, I don't think it's that big of a deal. But what I can do on the business power of attorney is put co-agents, and then there's also a place where you can choose, do they both have to act together or can one act without the other? Now, the caveat to all that is I have some reservations that banks are going to say, I want both of them here. I mean, they're doing crazy things, and I understand why. So if that's not an issue, with your family and people can both be, and when they say both, they want you there everywhere. And even, executors on your will, if you're putting co-executors, you both go to court, you both go to the bank. And I try to tell people, you can help each other out, but, don't make them co-executors. But anyhow, and it hasn't come back to haunt me as far as putting co-executors and somebody complaining, they won't do anything without the other. And if that happened, we would just redo the document, so long as the person's still capable and able to sign. But you have, it's such a powerful document, to just allow somebody to take over your life, your business life. I mean, I understand the guardrails that they have as far as it goes, but and having said that, I would say every 5 years renew it, because now they're complaining about stale power of attorneys. Okay.
Planning for death.
Who is complaining?
Huh?
Who is complaining?
Who is complaining?
Yeah, you said they're complaining about state.
Banks, title companies. They're wanting, I get calls all the time. We want an affidavit from me, which is a sworn document that I'm going to say, to the best of my knowledge, this person has not changed or modified or revoked this power of attorney. There are some clients that I will do that for because I've been working with them for years and know them personally. But there's really nothing else you can do, especially if the person doesn't have capacity to sign a new one. So how do you plan for death? A will. When people come to my office, I think it's, most people, nobody wants to go see an attorney anyway, because everybody's always worried about, they're going to look at how I organize things, they're going to look at how I do this, and I'm like probably one of the most unorganized people in the world, but anyhow. I don't need to know how much money you have when you come in. I don't need to know all your properties, because I don't know when you're going to die. So if we start listing, this CD and this CD and my only concern right now is, are you over $15 million? Because if you're over $15 million next year, then you're subject to estate taxes. And if you get hit with estate taxes, it's awful. It's 40%. So you're selling property unless you had this, big chunk of cash in the bank. But if you're not anywhere near this $15 million mark, then there's really that doesn't matter to me. I'm going to talk about the character of your assets, whose title's on everything. Some people come in there and, yeah, my husband died 10 years ago, but, the tax shows just my name on it. That tax office over there, if I walked in and said, I'm going to pay the taxes, they would put my name on there. So I think that's very deceiving. So we look at titles and make sure, the correct names are on all the deeds. Over and over and over, I tell people, go check your beneficiaries, make sure at the bank you have correct beneficiaries. Then, or I guess we might as well talk about the Lady Bird deed really quick. It has nothing to do with Lady Bird Johnson, zero. It was a case that somehow they drug the Lady Bird name out. But anyhow, it's an enhanced warranty deed with a life estate, an enhanced life estate. So what a Lady Bird deed is, you do it on your property, and it says, I am the grantor. I am giving to the grantee, which is whoever's getting this property. It could be one person. It could be all 10 of your children. The minute you die, if you still own the property, it goes to them without probate. And they get the date of death stepped up basis, which is a big deal now out here. It just, during your lifetime, you retain the ability to sell the property, give the property away, whatever you want to do. But whatever's left of that property when you die immediately goes to the beneficiaries, the grantees. Each property has to have a ladybird deed on it. So it's not something that you want to run and jump into, especially if you might be selling your house anytime in the near future, because each house has to have a ladybird deed on it. Any questions?
What about a Todd form transfer?
Same thing.
Same thing?
He's talking about a TOD, T-O-D-D, these acronyms again. T-O-D-D is a transfer on death deed. Now, that's a new creature, and the legislatures have allowed it because an individual can do it without an attorney. Okay, but it comes with, little hidden things that they don't tell you about. A power of attorney cannot sign a TOD. And there's some other little tricky things. I personally like TODs. I like them because you can be more specific. You can say when you die, or like when at the last of Gemini to die, then the house goes to this child. If this child is not alive, it goes to this child. So you can be a little bit more specific. And it is codified, so it's in our code book. The ladybird deeds were never codified. But it is a warranty deed with an enhanced life estate, and that's all codified. But on a ladybird deed, it says if child A dies, it goes to his heirs. And a lot of people, that's not what they want. They want it to go to the other child or something. So they just haven't been around long enough for litigation to happen. So
It was real simple. My elder mother did one, and just let the home residents, me and my sister.
right, that's good to know. I mean, I had a man come in the other day and he had done one himself, and it's amazing. But
I do have a question on that as far as you're saying if you're going to sell property, I guess, you think about if it's would you do a TODD from like me to my wife so that goes outside of, if I died and she's still alive, we would go ahead and probably want to do that. But then if we're in the process of going to sell property because you're going to move, where's the line of protection there, I guess, with that? Would you go ahead and do that, and then you have to roll that back when you get ready to sell the property?
no, the only reason I'm talking about not doing it if there's a potential that you're going to sell the property in the near future is the cost. You just have to pay for another deed. But yeah, most definitely, if you're both co-owners, if one of you died, it would go to the surviving spouse, and then at the death of the surviving spouse, if she hadn't sold it, then it would go to the kids.
But that would keep it out of the probate for her from a will perspective.
That would keep that one house out of probate.
Can you put more than one property on a
No.
TODD?
You can have a TODD or a ladybird deed on each piece of property, but each piece of property has to have its own deed.
So that's the same for land as well, I'm assuming. 'Cause I thought that it would be like an exhibit or whatever else they would list. You can't have an exhibit that has multiple.
No. Well, if they're contiguous, and they're touching. As any deed.
Like 2 acres on a 50-acre tract or whatever.
Well, some people have they carve out a 1 acre for ag exemptions and stuff. So they got a 1 acre here, and then they got 10 acres here, but they touch. So I can do that on one deed. Okay, so as you're going through life, the power of attorney you use while you're alive, the medical power of attorney you use while you're alive, the will does not happen until you die. And I think when we're having conversations in the office, a lot of people kind of, I'll still be here and I don't want them to have that. And so it's a mindset. So when you're in the office, and and I try to make it not so drab and sad, but it's hard to put your mind, ahead. I'm not going to be here, so what are they going to all do with this stuff? The purpose of the will is to dispose of property as you want. It's to avoid intestacy, if you don't like the laws of intestacy, and with a blended family, you probably don't. It allows for more efficient and less expensive administration of the estate. I'm going to tell you right now, you pass away without a will, and there's property, and there's bank accounts without beneficiaries. We're in probate without a will. And that's going to cost you about $3,000 more, because we have to file an application, list everybody that might inherit. We have to drag in 2 disinterested witnesses who are going to come to court to testify, yes, I grew up with this family. I would have known if they had 10 other kids. They had 2 kids. That's all I ever saw. Then the judge appoints attorney ad litem to make sure that we're all telling the truth. And you pay, or your estate pays that attorney. The judge doesn't pay for it. And then it goes through the laws of intestacy. So you go through all this, and it may not even, the distributions may not even be what you want. But if you don't have a will, that's what happens. They're very difficult, and now that we have all this internet stuff, the ancestry stuff, and the Me Too, whatever all the stuff is, then as attorneys, we have a duty to try to find people that are heirs of yours. And if we don't, then there's a lawsuit. So it's just so much simpler. I don't even know how I can even say that any simpler. Wills aren't that expensive, but if you care about the people you're leaving behind, do a will. The requirements of a will are the testamentary intent must be on the document. This is to be my last will and testament. And it's probably not going to be your last will and testament. It's not written in stone. People come back a lot and change their wills. You should look at your wills if you have life changes, if somebody gets married, if you have grandchildren, if somebody gets married and they have a stepchild, then we need to specifically say that if you want that stepchild to be included in your will. You have to be of sound mind when you're signing, and the capacity to know the objects of your bounty, and the capacity to understand the general nature and extent of your property. And I can guarantee you some of these people amaze me, 80, 90 years old. Of course, that's not that old anymore, but anyhow, they can rattle off to me metes and bounds and property, and if I get something wrong, they tell me. But they've lived on that land. They grew up on that land. They know that land. So, I'm looking at them thinking, do you even know why you're here, this, that, and the other? And then they can, read off the legal description. And again, that's really all that's important. I don't care what they ate for lunch or breakfast, or they played bingo last night. That's not part of what we're there for. And most of these people take it very, very seriously because they've worked very hard for their stuff. And there's certain people they want to have it, and certain people they don't. And no, you don't have to leave $1 to someone in a will if they're not getting anything. I don't like gray areas. So in my wills, I say, I have 2 children. My husband has 1 child. I am making no provisions in my will for X child. And some people don't like to say that in their will. But if you're going to leave someone out that is a natural beneficiary, then my feeling is you put it in the will, because that child's going to come back to me or to whoever and say, I know my mother didn't want to leave me out. Well, yes, she did. So anyhow, the importance of the ease of probate. Have the original will. We've come into this part of our world now where we don't have an original will. We have to bring in either the person who watched the person sign, because when you sign a will, you do it in front of 2 witnesses and a notary, so that we'll all go to court and testify. When you were here, you weren't, asleep, drooling on, you knew what was happening, and nobody had a gun to your head or had your arm behind your back. So that's the purpose of the witnesses. And the witnesses sign in the testator's presence, meaning, we all watch and everybody signs saying that they understood what they were doing. But if you lose your original, and there's only one original, I get calls all the time, I need another original. If you don't have an original will, then we go to court. We've got to drag in people who either watched you sign it or they recognize your signature in 1950 and they know that you were over the age of 18 and of sound mind. That's kind of easy.
Those people aren't alive.
There you go. Because some of these wills are done in the 60s, 70s, 80s, and all those people aren't alive. So we have to find people. And we found, like, postmasters in little small towns, they know everybody's signature. Or grandma sends, old grandma used to send birthday cards and sign her name, and grandkids recognize name or signatures. So, again, if it's a will that I've done, I love to probate my own wills because, I either notarize or somebody in my office witnesses, and so that's an easy thing. But keep your originals where your executors and the people who are going to take care of your estate can find them. Nobody wants to steal your will, so you don't have to hide it. What you're protecting it from is floods, fires. Although I had a guy the other day said, someone did steal my will. And I said, wow, you must be very important. And he said, they stole the safe I had it in. So, additional benefits of a will. You can give special gifts to people. Lots of times you have all this stuff, quilts, china, your silverware, your flatware, your antiques. And the younger generation, nobody wants it. Nobody wants anything. Yeah, my daughter tells me all the time, Mother, do something with all this stuff before you die, which is not what I'm going to do. But anyhow, but you can give special gifts to people who aren't even in your will. If you're a part of a book club, you can say, I'm going to give the book club all my little teapots that we drank out of. I'm going to give them all my books. I'm going to give the man down the street all my gardening tools. And within your will, you're allowed to keep a memorandum to your will. So you can write all those things that nobody wants on this piece of paper. Pots, pans, dishes, Tupperware. Had a man the other day, Tupperware. That's on the memorandum. But if you're going to give large gifts, like I'm going to give $25,000 to my granddaughter, then I'm going to spell that out in your will because I don't want that to get lost. If you're going to give a piece of property to someone, I'm going to put that in the will because I don't want to get it lost. If you've got Grandma Moses's 40-carat diamond ring, I'm putting that in the will. So all those things are specified. Now, if you die and you've already given it away, you don't have to have a new will. We just move on. And if the judge asks, where's the Grandma Moses ring? Well, we already gave it to her. Burial. You can include burial in your will. I want to be cremated. No, I don't want to be cremated. In Texas, if you're married, it's your spouse that signs the cremation or the burial form. If you don't have a spouse, then it's your kids. So if you have this feeling that your kids aren't all going to be on the same page about cremating you or burying you or embalming you, then we have a document. It's the person who's going to control the disposition of your remains. And you can choose who you want. The best thing to do is tell them, pay for it, and they don't have a choice. The digital world, I can guarantee you, if you go to one of these banks or and ask for passwords, you're not going to get very far. Even though I put it in my will that the executor can access digital accounts and assets, that seems like probably 5 or 6 months of begging and on and on and on. So keep a book. Keep just a running tab of passwords. I mean, I try really hard, but I'm always scratching them out and doing new ones. But it's really important to have, especially right after someone passes away. If you need access and you're allowed access to like a bank account and you know the password, then you can, be able to pay for things. They won't even let you shut down Facebook or any social media. So those are just things to think about. Pets, we all love our pets. We have 2 wild Yorkies at home right now. If you want to make provisions for your pets, a lot of people do. You don't have to do a pet trust. That's just extra money. But you can put in your will, I want Frankie, my Yorkie, to go to, John, and I'm going to give him $5,000 to take care of food and vet bills or whatever. Again, digital assets, personal assets. If you do a lot of Facebooking or TikTok, whatever it is, and you have stories on there, you have pictures on there, then you want your family to be able to access those, maybe or maybe not. But you will lose those if you don't make plans for them to recover them. As far as financial assets, again, make sure who your beneficiaries are, especially in the world we live in now with identity theft and things like that. And that's the reason that banks are becoming so much harder to deal with. I mean, there's a reason there. Business accounts, if you don't put a beneficiary to step up and take care of the business, if you pass away, payroll may not be able to be made. So you need to have someone as a backup to access your business accounts. I think we've already talked about what happens without a will. Again, if you die without a will and you're married, and you say you have the same children, it goes to your spouse. If there's children outside the marriage, then the children outside the marriage will get some of their parents' share. If there's no children, no spouse, it goes back up to mother, father, sister, brother, cousins, nieces, nephews, that kind of thing. So probate versus non-probate assets. A probate asset is a home because it has a title, unless it has a ladybird deed or a transfer on death deed. Autos are a probatable asset. However, we would never go through probate just for an auto. The Texas Motor Vehicles website is awesome with information. They even have a transfer on death deed, so to speak, for cars now. They have an affidavit of heirship. And if your car's paid off on your title, there's that minute little writing that says, rights of survivorship. If I die, this goes to whoever.
Well, the affidavit of heirship, can you transfer property? Well, we did with my mom and dad.
You can do an affidavit. That's like the lowest form of probate, which is good if it's only a house. Now, to do an affidavit of heirship, the estate cannot owe any debts.
Okay.
And it's going to go according to the laws of intestacy. So if you're a husband and wife and you share the same children, then the spouse gets the house, the deceased spouse's part. But if there's children outside the marriage, then they get a percentage of it. So,
if the house is only in one person's name, it's not in the husband or the wife's name, it's just in one of their names, is that still treated as married? And
it depends. If the origin of the property was before you got married, or if the origin of the property is an inheritance or a gift from someone, it retains its special character as being. I lost my train of thought. You're just your property, not community. You're separate. So yes, that would be 100% that person's property, and yes, they could sell it.
Is there a difference between oil royalties and property?
There's mineral deeds, just like property deeds. We can do a ladybird deed or a transfer on death deed on minerals. So they're pretty much treated the same way.
Would they transfer through a will?
Yes.
Okay.
You can transfer everything through a will. Most bank accounts are not probatable assets. Most investments, because you have beneficiaries on them. And life insurance, 401ks, CDs, any financial account that has a beneficiary is a non-probate asset. So make sure you check your beneficiaries and check how your property's titled. Some people have been living on land for years and years and years, and it's still got grandma and grandpa's name on it. And so we got to do something to get it into your name. In Texas, you have 4 years to probate a will. I have no idea why 4, not 5 or 3, whatever, 4 years. If you go beyond the 4 years, you have to explain to the judge why it is that you waited 4 years. Now, in Parker County, you're never going to have a problem. Other counties, they're tightening up on this. They want to know why. And historically, it's always been, well, I didn't know. I was married and we owned everything together, and he died, and, they told me, I'm the only one paying taxes, and so I thought it was in my name. So here we are 10 years down the road, she's trying to sell the house, and she can't because she didn't go through probate. So it's just something to be mindful about. There's a lot of reasons why people would wait longer than, the next week after somebody died. And, a lot of it has to do with, trying to gather assets. That's why it's important when you're sitting down and make sure that your kids know you have bank accounts in 10 banks. Make sure your kids know that you have all these credit cards, because they're the ones that's going to be taking care of it, after you pass away. Or spouse to spouse. A lot of spouses, one passes away and they have no clue because they've never paid the bills. So, and it's hard to catch up when you're in that situation. We've talked about the supplemental needs trust, and it's an invaluable document when it's actually needed. It's the only trust you can have and still apply for Medicaid. Because again, the theory is the person who has the disability has no access to the funds. The trustee does. So the trustee, everything that comes out of that trust is for this person's benefit, but they can't take money out themselves. And the criteria is pretty broad. It is anything that enhances the quality of life of the beneficiary. So if it's a person who, is he needs a new wheelchair, he needs a trip to Disneyland, and the whole family needs to go. It's just whatever enhances his quality of life, beyond and above what the government is supplying for him or someone else is supplying for him. The administration of an estate, so lots of people come in and they say, what is probate? So within your will, you will have chosen who the executors are. The executor is the person who gathers everything together after you pass away and determines whether or not you have to go through probate. If you do have to go through probate, it's the executor who takes it to an attorney. You have to have an attorney for probate unless you are the only beneficiary. If you're the only beneficiary in a will, you can actually probate a will yourself. You just got to figure out how to do the documents. Once you, if you're the executor, your first job is to secure all the tangible assets. So everything in the house, you should go through, make an inventory of what's going on. If you're not the only beneficiary and you got 5 brothers and sisters and everybody's wanting something, keep good records. That's all I can say. Because, Susie's going to want the grandfather clock, and Mary's going to want the sewing machine, especially if grandma hasn't, said who gets what. So secure all the tangible assets. If it's an equal division, you might set everybody around and say who wants what, or have an estate sale and sell everything.
Grandma writes on the bottom of the deal, just goes to say.
Mm-hmm. Well, yeah, or put sticky notes everywhere. Or somebody told me the other day they did that like by lot. They drew numbers, and you go first, and then after number 5 gets through, it's your turn again. And I just can't imagine being involved in that. But
I have a question concerning the supplemental needs trust. There was a scenario in our family, it was from another state, from Arkansas. And we tried to, the family tried to put the special needs trust in place. However, she was already on Social Security. So that became a real problem for her to receive any other income. I don't remember how that happened, but is there a provision of something like that here in the state of Texas?
Well, I don't know anything about Arkansas, But in Texas, if you're listed in the will as a beneficiary and you inherit something and you're on any kind of a means-based program, then that money is, tagged to you. Even if you decline to inherit, even if you say, I don't want it, they're going to say, oops, you had it for a nanosecond because they gave it to you. That's why in the wills that I do, and I'm sure other attorneys, it's so important that I say, if anything in my will goes to Johnny, it doesn't go outright to Johnny. It goes into a supplemental needs trust for Johnny. You have to get the cart before the horse, because if they already get it, it's theirs. And then if they try to put it into a trust, then it's a penalty.
The issue with our family in that particular scenario was that she was going to be removed from the Social Security benefits that she was disabled in an automobile accident. And so it was a real, I don't know how the family dealt with it, but it could be a situation for anyone to have to deal with.
It's a horrible situation, because especially if you're on Medicaid, and they're paying all your insurance and your hospital bills and your, nursing home stays, and you're off. It kicks you off of it until you spend down the money and reapply. So it can be very devastating. So if you have mothers and fathers or grandmothers and you have a disabled child and you know that they have your child or your grandchild in their will leaving them something, then you need to talk to them about it. Now, we do have a new law where we can reform a will to say, little Susie is disabled, in what she's getting, we're going to put into a trust. Again, that's a lot of legal work. It's money. We got to get a judge. Anytime you're going before a judge, it's going to cost. And we don't know exactly what they're going to say or do. But we are able to do that at this point. Does anybody have any questions at this point? So if you don't have legal documents to allow someone to help you with your business or to make medical decisions for you, then the only resort is guardianship. Guardian is very expensive. It is very time consuming. A person, again, is appointed the guardian, and then there's another person that looks over the attorney and the guardian. You have to put up a bond, you have to keep an inventory, you go to court once a month, and the judge looks over everything to make sure you're doing everything that you're supposed to do. It's invaluable that we even have it, but again, it's a last resort, and there's so many things you can do before you get there. So an incapacitated person is an adult who, because of physical or mental condition, is substantially unable to provide food, clothing, or shelter for himself or herself, to care for his or own physical health, or to manage his or own financial affairs. Now, when we're talking about having someone become your guardian, when you have these power of attorneys, like the medical power of attorney, your agent can never put you someplace you don't want to be. So if you're a danger to yourself or others, or you need to be in a memory lockdown, then this medical power of attorney is not going to keep you there. But for people who suffer, extensive issues where they have to be in a lockdown facility, or they're not cooperating, then a guardianship is the only way. And it's very important because, these people can't take care of themselves. They escape from nursing homes, and they do need a different level of care. So again, that's important. Tips for having to talk. Nobody wants to ruin a Friday night by talking about death and dying and what are you leaving me? And usually that comes up at the funeral. Did Dad have a will and can I see it? And so what I tell people, give it to them. Make copies before you go to the funeral. They're entitled to see it. People are either usually one way or the other. They want everybody to know what's in their will and who they're making the executor and who they're putting in charge right now, or they don't want them to know until after they die. Some people put, co-agents and co-executors, siblings that haven't spoken in 5 years. And, I'm like, why are we doing this now? And, they're like, well, I want them to get along after I'm dead. So again, personally, but again, the beauty of a will and estate planning, it's your deal. You can do whatever you want. But I just think, you need to, the more people in your family you let know where my stuff is, where I want my stuff to go, how I want to be treated if, I'm crazy and can't drive a car. Yeah, you can try to take my keys away, but, and what kind of life change, what do I want as far as taking care of me later on in life? So, and as far as wills go, what I want done with this. I would like to have everything sold and just divided. Take what you want. But again, it's important, and especially if you have, someone in your life that they need a will. Usually I get one family member come and then all the other ones trickle in afterwards. Especially because mom and dad are saying, I'm leaving everything to you, Joey, and to you, Bobby. What does your will say? Because people, they tell me, I want my sons to have it, and then I want their kids to have it. Well, wives don't inherit unless you say that they do, because they're not blood. So it's very important that you designate who you're giving things to, and tell them why. Don't just leave somebody out. Of course, usually they know why if you leave them out of the will, so you really don't have to tell them. Okay.
Questions, anyone?
Yeah, I got a question.
About 5 minutes.
I'm named on a trust. Do I need to do anything about that?
Well, how are you named? Are you a trustee? Are you a beneficiary? Or?
I'm not exactly sure.
Well, a lot of people come in and say, I need a trust. Somebody said I need a trust. So a trust is just this big bucket where you put things in, and it comes with rules. I want Joe to be my trustee. If Joe dies, I want Mary to be the alternate trustee. And I want it to last, 100 years. And if this person dies, it goes to their kids. And if this person dies, it goes to their kids. But in this day and age, because our tax laws are so high, 15 million, it's a nice amount of money. So you're not going to really suffer tax consequences if you're below that amount. Trusts are expensive to set up, and they're expensive to run. You file an income tax return every year on it if it's an irrevocable trust. And it's just amazing to me how loosey-goosey trusts are handled. The bank does not keep a copy of a trust because it's a liability. So, I was working this morning and I'm doing a deed out of a trust because there's nothing left in the trust and the person has died. But nobody really knows we even have this trust. It hasn't been filed anywhere. So, trusts are complicated. But they are good for people who can't manage things and you want to put everything in a trust for someone and somebody else manages it. I do lots of children's trusts, grandchildren's trusts. You got a chunk of money laying around, you want to stick it in a trust for your grandchildren. That's a good thing to do. Or we do management trusts where people own like a lot of property, like a real estate stuff. It's easier for them to manage by putting all the different properties in a trust. Other than that, right now, I don't see a lot of reasons for trusts.
I have two. You made a comment about, for instance, the kids are entitled to see the will. Can you explain that a little bit?
If you are a beneficiary in a will, then you're entitled to see the will. If you think you probably should be a beneficiary on the will, then I think that if it were me, I would show them the will. But if you're not a beneficiary, I don't think you're really entitled. But if you think you are, then it's kind of a...
So you can always go to the courthouse, get a copy of that, assume it's gone to probate already.
We don't file the will unless we're going to probate.
Yeah, understand.
Right.
But if it's gone to probate, then I can go to Parker County and request a copy of that will. Period.
I think so. I don't know. I've never tried to go... I mean, I can, but I don't know if you can.
Yeah, I have, because I got caught in a situation where an uncle passed away, and he had asked me to be the executor of his will. And when he passed away, I was shown a different updated will, and which I was not.
Okay.
So, second question, are you able to talk about step-up cost basis for properties and/or things like brokerage accounts?
I can talk about date of death, stepped up basis, yes. So on a Ladybird deed, you get the date of death, stepped up basis. If you inherit property, you get the date of death, stepped up basis. Which means, for all you non-accountant, I'm sorry?
We have to have a new appraisal?
It depends. What are you going to do with the property? You selling it or?
Let's say no.
No. What I'm going to do, after you go through probate, we put a letter in the newspaper to creditors to make sure there are no debts. Beneficiaries aren't responsible for the debts, but before the beneficiaries give themselves anything, the debts need to be dealt with. So after that, we do an inventory at 90 days or so after probate. And on the inventory, what I'm going to do, if there's a house involved, I'm going to put the legal for the house, and I'm going to put whatever the tax estimate was the year they died.
So if you have individual questions, I'm sure you could get a card from Michelle or Jim, either one, to answer specific questions. But I think she's done a wonderful job today.
Thank you.
In about 5 minutes, we'll start the next session.